Good afternoon. I'm Dennis Galucki, and welcome to the 564th Imagine Buffalo program and our 185th YouTube program hosted by the wonderful downtown Buffalo and Erie County Public Library. Thanks for joining us today. This program is created by the Center for the Study of Art, Architecture, History, and Nature, or C-SAAHN, as I like to pronounce the acronym, and ImagineLifelongLearning.com. Now, before we get started, just a little housekeeping. Everyone watching will be muted and your video turned off. If you have a question or comment, please type it into the chat box and we'll go through them at the end of the presentation as time allows. We are recording this program so you can watch it again later on the Downtown Central Library's Facebook page and YouTube channels. And please, we hope you share the link with others. Now, on to our featured speaker. Joining us today to discuss Buffalo's role in the United States' labor union movement is labor and employment attorney Peter Godfrey. Peter is a partner at the law firm of Hodgson Russ, headquartered in Buffalo. He is the firm's practice area leader in the areas of labor and employment, as well as worker classification and employment tax. Peter represents employers in matters such as wage and hour litigation, including labor negotiations and arbitrations, employment taxation and worker classification matters, discrimination and other employment-related litigation, and employment-related contracts. Peter practices regularly before the U.S. federal and New York state courts and before numerous administrative agencies. Peter is also the town attorney for the town of Grand Island and has also recently served as a member of Hodgson Russ's board of directors, compensation committee, and as the firm's diversity partner. I had met Peter, we talked, and I could tell he has an interest in the history of the labor movement, and that's the qualifications I want to explore here in the next half hour or so, and create a very good archive program as well as an enjoyable one for our viewers today. So let's welcome Peter Godfrey. Peter, take it away.
Thanks, Dennis. Delighted to be here. With a great deal of luck, I'll be able to share a screen for y'all here. Let me make sure I can do that, and you can confirm that it's made its way through.
Looks good.
Hopefully. All right. Well, thanks again for having me here. I'm a bit of a labor geek, and really think that Buffalo is the center of where it's all at from a labor employment perspective. I'm not originally from this part of the world. I grew up in the New York City area, but I've been practicing management side labor employment law for close to 30 years now, and it's sometimes messy. It's not always easy. I represent exclusively employers. I don't represent employees or unions. But so you may find it striking that my view is really sort of balanced. I mean, I think there's a very important role that unions have, and the clients that I represent on a day-to-day basis think that their employees are their most valuable asset. They're what keeps the wheels turning in industry and in everything that we do here in Western New York. And Buffalo has had an incredibly important part in kind of defining modern labor relations. And I included a couple of slides just around the historic background a little bit. Way before the National Labor Relations Act was enacted, there were sort of early societies formed in Buffalo that were kind of precursors to modern labor organizations, focusing on improving working conditions largely. Sometimes there were work disruptions, and as early as 1929, the state ledge made it unlawful to strike in New York, finding it to be a restraint on trade, sort of like a precursor to like the Sherman Act. Ultimately, that was unwound, but that was kind of the early taste of labor here. Um, Early unions looked a bit different too. There were apprentice societies that were focused on things like working children, which were a thing that was normal at the time. And largely trying to improve working conditions and address issues from a labor relations perspective. We had lots of early strikes in Buffalo, tailors, carpenters. Um, as time went on, there were a few really noteworthy ones. I found an old snippet around the stevedores strike. Stevedores, of course, unloaded the ships here at the Buffalo waterfront, and at the time, we were about among the busiest waterfronts in the world here in Buffalo. And I thought this lent a little bit of flavor to kind of what was going on in early labor organization in Western New York. Here's a snippet. Buffalo is a riot in 1862, began along the docks around 2 p.m. when police tried to break up a violent crowd of German and Irish stevedores. Buffalo stevedores were on strike because of a wage discrepancy. Thought they were supposed to get 20 cents an hour, and they felt cheated because they were often going home with 10. Reports from concerned citizens said that the stevedores had been seen looting barrels and lager beer and physically forcing workers within nearby warehouses to join their cause. This caused some local police folks to address the issue, including the small police force at the time. It's again 1862. Police chief was on the scene to confront the mob of stevedores, and ultimately ended up arresting the leaders. There was a fight that included stones and fists and clubs, and there was a singular revolver wielded by heroic police officer Darcy at the time, is how the story goes. Ultimately, the riot was resolved and labor peace ensued. But the types of strikes that we've seen over the years are certainly not something which is new in our part of the world. There were other strikes in the late 1800s involving railroads, and at the time there was legislation that had begun to make some social changes around the length of the workday, and some of the railroads decided to ignore the legislation, again causing a labor dispute, and the switchmen went on strike in that one. And as you can imagine, that comes pretty close to shutting down the world, as in 1892 when the switchmen are on strike. So what happened from there? Sort of fast forward to the 1930s, when the National Labor Relations Act, the Wagner Act, was enacted. It was, of course, named for Senator Wagner of New York, who had introduced bills that would give federal support to employee organizations and to collective bargaining. The act was signed by President Roosevelt and became effective the 5th of July in 1935. The cornerstone of the act is Section 7 of the Act, and that is modified a little bit, as I'll point to in a second, but is really kind of the core of it. That gives employees now, for the first time legally, the right to form labor organizations and bargain collectively through representatives of their own choosing, engage in other concerted activities for the purpose of collective bargaining and mutual aid or protection. Those provisions still largely remain in the Act, and they effectively form the kind of foundation of labor relations, the duty on both sides to negotiate collective bargaining agreements, and to, for employees to elect to be represented by labor unions, the right to strike where there's not a contract that prohibits such things, to picket and otherwise engage in concerted activities relating to terms and conditions of employment. It created the NLRB, which is a federal organization that enforces the National Labor Relations Act, and created things called unfair labor practices, which at the time were employer violations of law that treaded on employees' Section 7 rights, or otherwise limited their ability to organize and do the other things that were protected under the Act. It created a system with an NLRB then of 3 members to hear such cases. And there was a section of the Act, Section 10, that gave this newly created board various law enforcement authority to order cease and desist and to issue back pay awards and do other things for the purpose of enforcing the terms of the National Labor Relations Act. It was ratcheted back a bit. 1945, 1946, there were some massive post-war labor strikes. Those were really the biggest ones that the United States has ever had. They're certainly as a percentage of the workforce. There were nearly 5 million American workers involved in strikes during that time period. So in the 80th Congress of the United States, the Taft-Hartley Act was enacted, actually over a veto of Harry Truman. It was Republican legislation at the time, and it did a few things and sort of weakened the National Labor Relations Act. It increased the size of the labor board from 3 to 5, which is where it currently is. It created the General Counsel Office, which still exists. And certainly we've had, even in recent times, folks from Buffalo who have served on the National Labor Relations Board and been General Counsel of the NLRB. Our friend Mark Pierce from Buffalo was the chairman of the NLRB in recent years. Around the same time, Dick Griffin, lawyer hailing originally from Buffalo, was the general counsel for the National Labor Relations Board. So we've certainly made significant contributions to the board and to the case law through folks coming from Buffalo. But the Taft-Hartley Act also significantly weakened the Wagner Act, or the original NLRA, prohibited a number of their jurisdictional strikes and various other types of mass picketing, and essentially ratcheted back union rights in a number of ways. It also amended Section 7, that core section of the Act that I was talking about, so that it was not focused solely on employer unfair labor practices, but also gave employees the right to avoid restraint and coercion by labor unions, and prohibiting various action on the part of labor unions, and created a new set of unfair labor practices that could be filed against unions as well as employers. It also created the right for states to enact legislation that prohibited union protection clauses called union security clauses, like union shop clauses that require union membership as a condition of employment. So we now have across the U.S. a number of states, typically aligned with some of the red states in the U.S. that are right to work states, where it becomes a lot harder for unions to really get a foothold because they can't require membership in a labor organization as a condition of employment for employees in those states. But it created unfair labor practices against unions itself. And it also sort of incorporated the First Amendment into the NLRA. Section 8C of the National Labor Relations Act kind of balances out the employee rights in the Act and says that the expression of any views, argument, or opinion, or dissemination thereof, whether written, printed, graphic, or visual, shall not constitute or be evidence of an unfair labor practice under any of the provisions of the Act, as long as there's no threat of reprisal or force or promise of benefit. What all that does is basically give employers the right to speak their mind, and effectively incorporates the First Amendment into the National Labor Relations Act. So where have we gone from there? We've had now 90 years of collective bargaining under the NLRA. I screenshotted a couple of the old collective bargaining agreements that I have. I think I have a full drawer full of agreements for some of the clients that I work with that span back to the 40s and 50s and throughout today. And this is kind of the core of the Act, and this is what employers do on a day-to-day basis, is try to negotiate collective agreements that set the terms and conditions of employment for folks across Western New York. These are some examples of some early contracts for different companies in Western New York from the 40s and 50s and 60s. Labor kind of hit its high in terms of union density across the United States and in Western New York in the 50s and 60s. By the 70s, it really began to decline a bit. I think the unions were to some extent victims of their own success as various social legislation was enacted to protect things which unions had previously negotiated, like minimum wages and other workplace safety rules and things like that, which were largely the domain of unions protecting workers. Sort of safety net began to be built out, and perhaps that's some of the some of what's made it more challenging for labor organizations over time. But you can see public employees are one area which has kind of become quite a stronghold for unions. And in recent years, there's initially many states didn't allow public employees to organize, and as you can see, that became more popular here under the Taylor law in New York. The 60s and 70s, as we began to negotiate collective agreements for school districts and other public employers, municipalities, counties, public universities, et cetera. There's still a fairly significant stronghold that remains for organized labor. But organized labor is in Western New York is quite strong in relation to the rest of the world. Here's a quick chart from 23. You can sort of see what Western New York looks like in relation to the rest of the world. Maybe a bit hard to see, but we're still in the world where in New York we have 20% or more of an organized workforce, which is more than almost anywhere else in the United States. In some years, California it shows up a little higher, and some years Hawaii is a little bit higher, but those are pretty high numbers. I think these numbers I brought a little bit forward from the last chart, but here's kind of the top list of places where you'd expect. And there are places within private sector labor where we do see rates at a relatively high number overall. But nationally, at the end of last year, we were down to 9.9%, and New York State averaging 20 altogether, and the Buffalo and Niagara region, depending upon where you are, around 15%. As you can see, the percentages between public and private employers is a huge difference, right? We've got 65% of public employers, so those numbers all factor into those overall aggregates across the state. But it's really been a tumultuous time. I mean, here in Western New York, we've seen all kinds of ongoing organizing efforts, cases like the Starbucks case, and Amazon from downstate New York, which has been well publicized, really kind of highlights some of what new organizing activities by labor organizations looks like today. It's not your grandpa's union of kind of the old guy with a cigar. I mean, a lot of the folks that are involved in organizing now are young and way more hip than I'll ever be, and do relate well to employees. And I think that's been kind of the trend that we've seen in organizing. But of course, January 20th just happened, and we now have a new president, and he's got some policies which flip-flop the labor board quite a bit. One of the first things that President Trump did was a bit unprecedented. He fired a member of the National Labor Relations Board, moving the composition of the board down to 2 out of its 5-member composition. So effectively prohibiting it or making it impossible for it to take certain action. Member Wilcox has sued, and we'll have to wait through the courts to see how all of that plays out. But minimally, there's some spots in the labor board that the president will be able to appoint. One of the things which is most challenging about labor is the manner in which it sort of flip-flops back and forth with the administrations. I think most of the clients that I represent would be happy to have, understand what the rules are and not have the rules of the game change constantly throughout from administration to administration. But labor is one of these areas where the executive branch has really wielded significant authority through the NLRB and through appointments to materially modify legal requirements. rules around, things like employees' rights to be represented by unions during disciplinary action under a case called Excelsior have flip-flopped back and forth over the years, depending upon who's in control, as well as union election procedures and all kinds of other activities that the board has moved forward with. Certainly under Jennifer Abruzzo, the prior general counsel of the NLRB until just a couple of weeks ago, the direction of the board had been, a very, very pro-labor direction. And there were lots of changes made to all kinds of things, from non-compete agreements to handbook provisions to, you name it, that in many cases changed many, many, many years of precedent. Things like captive audience meetings, by which employers could have meetings with employees about labor relations matters. New rules came out through the GC's office and through board authority in a lot of these areas that I'm mentioning, that I think materially swung the pendulum in a way that is far more to the left than perhaps it's ever been, and that makes it a bit challenging. One of the other interesting things to follow is the SpaceX case. Yes, Elon is everywhere of late, but one of the cases that he filed for his SpaceX company fundamentally challenges the core and the structure of the NLRB. NLRB, in some ways both exercises, legislative and judicial power the way that it's been at least using its power in recent years. It's got administrative law judges, and it's also, the appointment structure through the executive branch. So it kind of plays both, the executive and legislative and judicial roles in what it does. And part of the SpaceX case challenges the NLRB's existence as being unconstitutional, the way that it's put together today, as well as the absence of a jury trial under the Seventh Amendment to the U.S. Constitution. So stay tuned to see how that goes. But most recently, the NLRB itself withdrew its objection to the position that SpaceX was taking. So just last week filed a letter with an appellate court, Fifth Circuit Court of Appeals, indicating that it's not going to address the constitutionality argument. So it'll all land on the court to either figure out the law itself, but the labor board itself is not going to be making arguments in favor of its own constitutionality. Who could have predicted that? But in an area of what happens next, who knows? In a world of the constantly changing and swinging pendulums of changes from administration to administration. But I think one of the things that is core is that sort of look at the role that we've played here in Western New York. I mean, we're the labor organizations and management, by and large, work well together and cooperatively and accomplish all of the products and goods and things that come out of Western New York. There's certainly times that we butt heads between management and labor, but at the end of the day, it's, as I said when I started, it's a messy process, but at times, but it's about the best that we've got. So with that, I promised Dennis I'd leave a couple of minutes for questions, and I'd be glad to take any that y'all might have.
And you did, and we will. Peter, let me ask you, while people are gathering their thoughts for questions, Hodgson Russ has done this community a great service around the architecture of the very headquarters that it's in. You have a museum in the lobby that's open during the day, weekdays. And my thought was, you've just created with your text the backbone of an interesting museum on labor here in the Buffalo area. Something to consider. Maybe it's been considered. Maybe it would make sense. Maybe not. But I thought poster board, somehow a simple display, those booklet pamphlets you have going back to the 40s. I picture in some nice case in a museum setting.
I can imagine somebody taking that. So I appreciate the kind words. Yeah, I'm speaking to you now from the Guarantee Building in Buffalo, which is a Lewis Sullivan building, which we purchased to save it many years ago. The firm had its home here for a long time and had moved away, and the building sort of fell into disrepair, and we bought it in the early 2000s and completely renovated it. It's our Buffalo headquarters, and certainly this is our largest office. We've got about 250 or so lawyers around the country, but the majority of them are still here in Buffalo, New York, where I'm speaking to you all from. But appreciate the kind words.
Well, it's something to consider. I mean, labor history, it's fascinating. Also, I am curious, what was provoking that union, the striking mode post World War II, 1945 and 46? What was?
Yeah, I think that we're sort of coming out of the war, right? There had sort of been this great effort where everybody kind of contributed to the war effort. You had a lot of soldiers and folks coming back to the US, and the war was sort of behind us. It's the beginning of the kind of baby boomer time, and now the war is behind us. I think as I said, in the year after VJ Day, there was 5 million Americans were on strike, and yeah, that was the 80th Congress where they overrode Truman's veto to enact the Taft-Hartley Act, which, I mean, at the end of the day, still retains the core provisions of the National Labor Relations Act, the Wagner Act, as it was originally enacted, and maybe balances it out in some ways. At that time, you had a number of Dem legislators crossing and siding with the Republicans, who were all looking at this kind of, national labor crisis that was affecting the country. And at the same time, there were a number of union abuses, feather bedding, certain things that were, perhaps not in the best interest of the employees that they were serving. And it allowed for, holding both labor organizations as well as employers accountable for complying with the labor laws. But
Good. Good.
kind of
All
our
right.
foundation.
Melissa, how are we doing for some questions?
We do not have any questions yet.
Well, folks, keep thinking. This is a good opportunity to ask those questions. Your history goes back, as the other one that I found interesting. Was it 1862? And you think, here we are, the country's fighting a civil war, and suddenly there's a union activity here identified in your historical.
Yeah, it goes through the whole time period. I mean, nothing's really changed. I mean, I've dealt with labor disputes even within, my career in doing this, that are, have been messy. I've had, construction guys trying to get onto a job site who were non-union, who were, blocked by union folks, and, fights ensued, and police were involved, and property was damaged. I mean, at the end of the day, these types of things, which, today seem like this must be the worst that it ever was, there's lots of history to go back and see that it has been messy at different points in time in the past. But as much as that gets headlines, I don't really think that that's indicative of, kind of the way that labor and management work together. I mean, I said when I started that, my client's most valuable asset are its employees. And we often disagree with labor unions on all kinds of things. We certainly don't always get along, and sometimes we end up litigating issues and disputes, and certainly there can be work stoppages. But while they get the headlines, that certainly doesn't happen most of the time. Most of the time, employers try to do the right thing by their employees, and value their employees, and there isn't hopefully, if they're doing things right, there isn't a fight to be had. Sometimes there's good insights that can be offered from the employer labor side that help improve things generally, but there's a lot more cooperative relations, I think, in the world than there are the types of disputes that tend to grab the headlines.
Mm-hmm. Melissa, you popping on? Is somebody coming in with a question? Good.
Yes, we have a couple of questions. First of all, just regarding the history of Hodgson Russ, have two former presidents worked at Hodgson Russ?
That is true. Was somebody Googling my website? But yes, both Millard Fillmore and Grover Cleveland were attorneys at Hodgson Russ over the years. We were called different things over the years as the names changed. Actually, when I joined, it was Hodgson Russ, Andrews, Woods, and Goodyear, and the trend became in the 90s that there was too many names, so we're down to Hodgson Russ now. But Millard Fillmore and Grover Cleveland were both attorneys with this firm over the years.
That's certainly a neat little tidbit. Another question, do you think that Starbucks and Workers United will ever agree on a contract?
I wish I had a crystal ball for that one. Certainly that was a dispute started local that had national undertones. I've tried to not address specific like current labor disputes too much. You may have noticed the material I put together, just because I don't want to weigh in if I have client interests on one side or the other. But I think at the end of the day, the labor board here in Buffalo found that some of the activity that Starbucks was engaged in a campaign were things that it believed didn't comport with the labor laws. That doesn't mean that there can't ever be a resolution of a contract, and sometimes parties decide that that's in the best interest to bury the hatchets and move forward cooperatively. But certainly there may be legitimate reasons that they've got a beef between them around whatever activity may have occurred, and I'm sure Starbucks disagrees with various decisions that were issued in connection with its case. So we'll have to wait and see. I think for the most part, ultimately, the vast majority of collective agreements do settle. So statistically, for whatever that's worth, you can consider that, that just because it happens 95% of the time doesn't mean that there's any hope for the other 5%.
Thank you. Dennis, those were the questions that we received.
But one visual that you put up, Peter, was that union density chart.
Yeah.
Roughly in 1950 at 35% or so. And then it went on a steady decline. And I couldn't help but make the correlation with population declines in the Great Lakes.
That chart was really a national chart, though. The next
Yeah.
one I had beyond it was the local one. Certainly this is what we see. I mean, in New York and in Buffalo in particular, union density is relatively high as compared to the rest of the United States. I mean, we're still up in New York State in the 20% plus world in recent years, even while the private sector and for the rest of the country is down below 10. So the union density still is quite high here. It was higher in the past than it is today too. So we've certainly seen a decline in Buffalo, correlating with, kind of in proportion to what the decline was across the country. But we still do have very, very high union density. It's hard to be anti-union in Buffalo with the history that this community has. I mean, everybody's got a grandpa or an uncle or themselves have, worked in a labor organization. So, even folks that may disagree with labor from time to time, don't hate labor. It's not that type of a relationship. It's more, when there are disputes, there are, legitimate business disputes about different things, but it's not an ad hominem type of thing for the most part.
Good. Well, we can wrap it up there. It just that graph just paralleled Buffalo's decline in population, Cleveland's decline, Detroit, all the Great Lakes cities had the 1950 peak, and are just starting to flatten out after a 60-70 year decline, basically. So who knows how that will look going forward.
Oh, when the Bills win the Super Bowl next year, Dennis, everybody will be flocking to Buffalo. So
there you go. Like they all flocked to Kansas City, I'm sure, over the last 2 years, or not. Peter, thank you. Again, this is an interesting part of Buffalo's history, and that's why I wanted to make sure it was archived for the library and for all of us to appreciate that fairly unique role that Buffalo has served and continues right through current events to be serving in the U.S. Labor movement. So, Peter, thank you so much for joining us today. And let's check out who we're going to be bringing in next week. Let's see, we're going to have Sharon Holly and Lily Wiley Upshaw. Now, they'll be discussing this year, 2025, at the Nash House Museum and Michigan Street Baptist Church. You've seen all the activities starting to be generated, signage going right over Michigan Street. That area is being developed, and it'll be an interesting story. So we hope you'll join us next week, and let's get caught up on that story. I'm Dennis Galucki. Be well and good day.